Actually, when it comes to eligibility of people to stand as sureties.
In the wake of bail denial of Erias Lukwago, UBC crew sought to understand the legal gymnastics which are considered when granting bail to the accused. Dr. Tusasirwe is a senior lecturer at the School of Law Makerere University and a legal practitioner. He notes that granting bail remains a matter of judicial discretion guided by constitutional principles, bail guidelines, and court precedents.
The court just uses objective criteria and looks at the situation as a whole and says, is this a person who is in a position to responsibly remind the accused person to attend court? You don't have to be able to physically compare the person to attend court, but you should have enough social status for the person to know that when you remind them to go to court, they will. So I think that one she got right. Even the one of distance, she got right. There is no law which says you must be in the same locality, that you must be an immediate neighbor to stand surety. No. Again, the whole question is objective. Are you in a position to communicate with this person? And you can communicate in many ways, by phone, physically, you can travel there.
He adds that while serious medical conditions are relevant considerations, they do not automatically entitle an accused person to bail. The judicial officers are expected to carefully evaluate medical reports alongside all other circumstances of the case when granting bail.
But you could question whether you cannot release a person on bail, especially when you have admitted that he has serious medical conditions, just because investigations are not completed. And to me, it's not enough. The saving factor is, she said, let them examine him. If they advise us that he needs to be out, then we can reconsider this question. So they still have that window. That's the mistake many people make. There is no constitutional right to bail. There is a constitutional right to apply for bail. But once you apply, whether or not you get bail is discretionary, is within the discretion of court.
On the offense of misprision of treason, Dr. Tusasirwe explains that it arises where a person has knowledge of treasonous activities but deliberately fails to report them to authorities within a reasonable time, an offense punishable by life imprisonment upon conviction.
Misprision of treason is an old of common law offense. It arises where a person knows that another has not only considered treason, but has taken steps towards committing it, and you sit on that knowledge. Article 17, clause 1F of the Constitution, which says every citizen of Uganda has an obligation to help the lawful agencies in the maintenance of law and order.
Tusasirwe further notes that advocates are generally protected by client confidentiality unless information relating to the alleged offense was obtained outside the advocate-client relationship.
An advocate has a duty of non-disclosure of information concerning his client, which comes into his possession by virtue of his position as an advocate. And that duty continues even when you cease to represent the person. Unless you got this information as a private citizen outside your professional obligations, you cannot.
Crispus Adinitwe reporting for UBC.